including human factor analysis, that would have been in a position to provide testimony to the jury that, given all of the various factors in place at that night, not necessarily just the matter of intoxication, but a laundry list of factors that were known to be in existence at that time. And he would have been able to provide expert testimony to the jury that it would take much longer than 1.5 seconds for a sober person to detect and perceive the presence of this trooper and then ultimately take evasive action. And that it is our position that the trial court abused its discretion in not allowing the defense to present this testimony. And this exclusion was exacerbated by the prosecution in their closing argument when they, first of all, argued to the jury that 1.5 seconds is in fact sufficient time for an individual to perceive, react, or perceive, detect, and react to the presence of this trooper. And we were left as the defense with no evidence to cite to that would rebut that argument. And the prosecution went on to argue that that there was no other conclusion that could be drawn here, that he had to have perceived this individual, and that the defense had concocted this theory of what was described as a wall of light without any evidence to support that theory, which is precisely one of the reasons why the defense wanted to present the testimony of Mr. Lippitt. And all of that, of course, dovetails, so that is our first assignment of error, and all of that would dovetail into the issue, the assignment of error that relates to the sufficiency of evidence as it relates to count one, the felonious assault count, in that there was absolute...
Counsel, before you move on,
Yes.
Was there anything in the trial court findings or discussion relative to denying the defense the opportunity to present this evidence that suggests that the trial court determined that it was within the knowledge of jurors whether or not the individual could be observed in that time? In other words, it's not something that expert testimony would be necessary.
I think I understand your question. And the short answer to that question is no. That there was nothing in the trial court's discussion or comments or explanation that would suggest that was the basis, or that he made such a finding as a basis in denying the defense the opportunity to present that testimony. It was more along the lines that it would be confusing to the jury and potentially misleading. And what
It's sort of a different way of kind of saying the same thing?
I don't think so. And I think that what I understood, at least, the court's explanation would relate to this misunderstanding about there being discussion of voluntary intoxication. As we all know, the Ohio law specifically prohibits voluntary intoxication as a defense to vitiate a culpable mental state. But in that same statute, it goes on to explain that it means voluntary intoxication is certainly a fair game, if you will, to establish whether somebody is physically incapable of engaging in the act for which they are accused of. And what I perceived at the trial court level was their concern by the trial court judge that there could be confusion on the part of the jury if this expert testimony would be allowed in drawing that distinction between what a jury can fairly consider in terms of the issue of voluntary intoxication versus what it is not. And might I add that, contrary to the prosecution's closing argument which went along the lines something like, we all drive on the roads every day and are forced to make split-second decisions, and 1.5 seconds might, to a layperson, seem like a short time, but in fact it's quite a long time, is belied by what Mr. Lippian would have testified to, that a typical person, when confronted with the various circumstances that were known to exist at this particular time, would be physically incapable in less than 2.5 seconds of detecting, perceiving, and reacting to the presence of this trooper. So it is not within, I guess, for lack of a better word, common knowledge of a layperson to truly appreciate the time it would take for a person to react and perceive, detect, and react. And as I was saying, all of that dovetailing right into the issue of sufficiency of the evidence as it relates to that first count of felonious assault, in that there was absolutely no evidence in the record whatsoever that Mr. Thompson essentially knew that there was a second law enforcement officer on the scene, and in that brief period of time where he was driving down the driveway and headed towards the road, there was a state trooper, at nighttime obviously, in a gray uniform, standing behind the headlights of his car, while there was a second law enforcement motor vehicle who also had a spotlight and headlights on. And that second individual, the first law enforcement officer on scene testified that he was actually making eye contact with Mr. Thompson, as he was essentially turning around and headed down the driveway. And the point is that there's no evidence that he even knew of the presence of a state trooper standing at the end of that driveway. And even assuming arguendo that he was aware of the presence, that he would have had sufficient time to take evasive actions. And therefore, there's no evidence that he intended to use his vehicle as a deadly weapon to strike this officer, as opposed to merely trying to evade or get away from the first officer on scene. So we've raised a number of assignments of error in several issues, but at the heart of it all would be those two points that relate to the denial of the defense the opportunity to present this expert testimony, and then the complete lack of any evidence whatsoever to establish the fact that he was aware of the officer and had an opportunity to take evasive action.
Now, as I was reading the brief, it wasn't clear to me whether you were arguing that at the time the first officer approached the client and he came up to the car, observed the passenger, I believe, vomiting on the passenger side. He approached the driver, and the driver made eye contact with him. Is your position that your client did not know that the person who was approaching on the driver's side was a police officer?
Well, let me...
The brief is somewhat vague in that.
Sure. And might I add that Mr. Thompson did not testify at trial.
Right.
And I would respond by, first of all, pointing out that the first officer on the scene testified that he pulled his car up behind Mr. Thompson's car and did not activate his overhead lights.
Correct.
And as he approached the driver's side of the vehicle, I think he testified that Mr. Thompson essentially turned and looked over his shoulder, made some eye contact, and and it would not be clear from the record as to whether he knew that that person was in fact a law enforcement officer as opposed to a private citizen.
Did the officer indicate how he was dressed,
In uniform.
including the hat? We'll check.
Yeah, I wouldn't want to say one way or the other specifically as he testified. You know, I know that he testified he somewhat hastily got out of his vehicle and approached Mr. Thompson's vehicle. I honestly can't recall if he testified specifically about the hat. But also on that note, that same officer testified that he was unaware that the second officer had arrived on scene until the events transpired further. With that, then, thank you, and I appreciate that, and I'll see you again in a few minutes.
May it please the Court, Mr. Bradley. I'm Nathan Shaker on behalf of the appellee of the state of Ohio. Regarding the exclusion of the expert report, obviously the state's position remains the same, that it was not an abuse of discretion for the court to find that the probative value was substantially outweighed by the possibility and the strong possibility of jury confusion. Getting to Mr. Lippian's report, I think it's important to address Choya Han's report, essentially about the ballistics. Mr. Han's report was made based upon measurements he took from photographs. On page 94 of the transcript, he states that he didn't actually view the physical evidence prior to creating his expert report. Those measurements are the core of both his report and Mr. Lippian's report. Mr. Han's report, based upon the measurements he took about the bullets entering and shell casings, is brought up this 1.5 second figure that I believe also came up some other time, but that's the core of both Lippian's report and Han's reports. But he created that information in an improper way. I don't believe that was reliable, and I believe that can be part of the court's decision in determining if there's no probative value to his report as well as to Lippian's report. Mr. Lippian testified that his report, including his ultimate conclusions, were based upon Mr. Han's report, specifically the measurements. That's when he goes through the perception and reaction time and his calculations of could this have happened in this amount of time. Those are based upon faulty measurements, we would conclude. And that leads to reducing their probative value. Regarding Mr. Lippian's report, the appellant kind of attempts to brush aside what his ultimate conclusion was. Page 83 of the transcript, he testified that his conclusion was about culpable mental state. He kind of goes on and waffles and says it's not about that, but I believe it's in the last paragraph of his report. The voluntary intoxication keeps coming up in this, and that's just ripe for jury confusion. Just even separating that out and focusing solely on the perception and reaction time, that all leads to the conclusion that voluntary intoxication was involved in this improperly under 290121C.
Well, the statute does say, and I know this is one of that the person was voluntary intoxicated, maybe this will show whether or not the person was physically capable of performing the act. What would be an example of that?
I believe defense counsel cited to an 11th district case about an individual operating a bulldozer and somehow lowering the bucket onto a police officer.
What would be an example of real?
I'm sorry?
How would you see that as the prosecutor?
How would we see that as the
Give
prosecution?
me an example as the prosecutor that you would say maybe you would prosecute somebody if they're not physically capable.
In this case, it would be, you couldn't start the car, you couldn't turn the steering wheel. I mean, it would be fairly, I think, you, not just, in this case, we're hedging to get from.
It doesn't have to be the case. I'm just talking.
Sure.
about-
In general, I would be something, I mean, it would have to be clear cut, that obviously I don't want to use the definition and say, but you know, you don't have the present ability to open the door, get in the car, put it in drive. I mean, that's physical capability. It's not physical capability to perceive something is a stretch to get to mens rea. In this case, and I understand your hypothetical, I guess the way I read that, evidence that a person was not voluntarily intoxicated may be admissible to show whether or not a person was physically capable. I read that fairly strictly, that physical capability means, again, in a rape case, you can't physically rape somebody because you're passed out drunk. I mean, something along those lines. It's much more overt here, where I think it was a hedge on Mr. Lippian's part to use his perception and reaction time to get to mens rea. I don't think it was, even though it's couched in that manner, I don't believe that's the intent of the statute when you're talking about physical capability. To say you're physically capable, I mean, when you're talking about perception and reaction time, is that physical capability or mental capability? I mean, obviously that's involving a mental process above physical capability. And I think the statute says physical capability, so I read that at its face, that it's something that you are, just your body will not let you do. It's not the mental process to allow your body to do something, which is what we have here. And I think that is the distinction. Further, I guess I was getting to that cutting out Lippian's ultimate conclusion and his statements about involuntary intoxication wouldn't necessarily reduce jury confusion. Going with the problems with Mr. Hahn's report and Mr. Lippian's reliance on that, there's still less probative value and there's a substantial possibility of jury conclusion. So I believe that there was an abuse of discretion and excluding the report. Getting into the sufficiency of the evidence, it's been indicated that there's absolutely no evidence that the mens rea of knowingly was established. Well, obviously, we don't have a confession from the defendant, so we have to establish that circumstantial. There's a great amount of circumstantial evidence in this case that was established. As the court had alluded to, the defendant was aware that that there were other people in the area. And because circumstantially, he observed the first officer, Sergeant Conwell, approach his car, he took the evasive maneuver to drive through a yard. It wasn't like he just was like, oh, I want to get out of here, I'm going to turn around and go back down the driveway. He evaded the first Worcester Police Department cruiser. He went around a tree, came down a hill, and that's where, from the record, there's a jury view in this case, and the exhibits that explain the topography of this area are really important, because he was forced into this narrow area where both Trooper McClintock and Sergeant Conwell testified that Trooper Conwell was situated. There was really no way to the right, to the left. It was either stop or go forward. The defendant chose to go forward. Sergeant Conwell said that Trooper McClintock was illuminated by the lights of the vehicle, indicating to him that he was in a position behind the vehicle, that he was able to see Trooper McClintock, and the defendant chose not to stop. That's a very similar position to what Stephen Thompson was in. I mean, he was actually behind the wheel, looking down this narrow area, and there's a trooper illuminated by his headlights.
So the trooper was between the headlights of the first vehicle or the second vehicle and the oncoming Mr. Thompson?
I guess my recollection of the scene was there's this, obviously driveway goes up, grass area to the left or to the west of the driveway that is not particularly wide. Not so much more, especially where the driveway enters the roadway, it's not more than 2 or 3 car widths wide. So the cruisers are on the driveway. The defendant's vehicle is traveling down this grass area. To his west is a very steep embankment that he eventually runs into. The vehicle couldn't go over that embankment from the photographs. So he's funneled down in this area between where the cruisers, well, one of the cruisers is in the driveway, the other one I believe is just on the apron of the driveway, the state troopers, and he's getting funneled down into this area, and I believe there's a telephone pole just around, or a tree just around where the embankment drops off. So he's in between, forgive me for not calling the distances, but he's in between that embankment, that telephone pole, and where the cruisers are parked in the paved portion of the driveway, which is not a substantial, I don't believe that there's even 2 car widths there. So he has to go through them. And that's where he testified he was at, and that's where Sergeant Connell testified that he was at. And Sergeant Connell's testimony was, I believe, that the trooper was illuminated by Stephen Thompson's headlights, the headlights of his SUV, not the lights shining to the north up the drive. So in terms of the nature of the evidence for the felonious assault case, I believe looking at Stephen Thompson's continued behavior, that he continued to be belligerent, he continued to fight, that's all circumstantial evidence that gets us to mens rea, and that viewing evidence in the light most favorable to the state gets us to proving the felonious assault, and that there was sufficient evidence regarding that.
Did you in your brief say, refer to the evidence is overwhelming?
I believe, in one portion regarding the, talking about either in the jury instruction, I think I went down the harmless error route there. And I do think in terms of the assault on Trooper McClintock, not the felonious assault, the assault on Trooper McClintock and the assault on Deputy Shelley, where the defense contends that there was a problem with the jury instructions there. That was overwhelming. I mean, Deputy Shelley had visible marks. There was multiple witnesses to that. In the same with, I believe, at least 1 or 2 other officers viewed the assault on the ground of Trooper McClintock. In saying that, I guess my point also was that the defense is making an issue of jurisdiction in those. There was no real argument about whether those individuals were on duty. That argument was towards Sergeant Connell, who announced the head of his jurisdiction, but for the assault in the jail, in the assault on the roadway with the trooper, I don't think there was really any contention that both of those individuals were acting in their official duty and they were within their jurisdiction. I mean, what was raised by the defense was initially more so the traffic stop and the jurisdiction of Sergeant Connell to be there because he went outside of the Worcester City limit. Finally, regarding assignment of Air 7, having looked at the Bonnell case further and this court's interpretation in Santa Maria, I do believe that this case does have to be remanded for resentencing. I don't think there's any doubt about that, and I don't have any argument about that. With that said, the state would rest unless there are any questions. Thank you.
Counsel, you have just 3.5 minutes.
Thank you. The state states to the court that there was, the trial court was correct in excluding the testimony of Mr. Lippian because there's a strong possibility of juror confusion. But frankly, that's a conclusion, but really not an explanation as to why there would be any confusion over this testimony. And the only potential area of, I guess, confusion would probably relate to that whole issue of what is proper and what is not in the context of voluntary intoxication.
Which is a big issue, isn't it? That's
Well,
a big issue.
certainly, but number one, we already know Ohio law allows it in certain circumstances, so they are essentially saying that in the correct circumstance, there is no issue of juror confusion. Number two, the court certainly could have provided a limiting instruction. And number three, the court could have altogether prohibited Mr. Lippian from including the issue of intoxication in his discussion as to the various factors that would have precluded Mr. Thompson from being in a position to perceive or detect, perceive, and then react. I guess the biggest point I would want to bring to the court's attention here is that the state argued, and I think the trial court was confused on the whole issue of voluntary intoxication, and it was but one of numerous factors that Mr. Lippian cited as the reason why there would not have been sufficient opportunity, or Mr. Thompson would not have been physically capable in that 1.5 second period of time of seeing that trooper down there. And then, even if he did see him, have the ability to take evasive action. And you know, when the prosecution says, well, we can look at his conduct, his belligerent conduct after, as somehow substituting or establishing that he saw that trooper, is just simply not correct. It's such a short period of time that this whole case largely revolves around, 1.5 seconds. And there's also the notion that Mr. Lippian largely relied on the conclusions of Mr. Hahn. That's not correct. Mr. Lippian issued a 13-page report here. There is barely reference to Mr. Hahn's conclusions, and those conclusions that he does cite to relate to establishing that approximate 1.5 second period of time, which is a fairly simple calculation. It comes down to distance and speed equals how long it would take for a vehicle to travel. And those distances were established by the state's accident reconstructions. They took a total station out there and provided a document that was to scale, so it was clear how much distance we were talking about. And then there were speed estimates provided by both law enforcement officers, and so that all that information, I guess, that was used to establish the approximate 1.5 second period of time came from the state's evidence and witnesses. So it is not correct to suggest that Mr. Hahn had not been at the scene and he was just making this information up.
And Council, you have reached the end of your line. Thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and should make a decision to be sent to both sides as well as posted on our website and the House Criminal website.
Thank you very much.